Protect privacy. Privacy is the right of an individual to control his own information. Asset privacy, ensuring that organizational assets have the level of privacy that is needed. Today, individual privacy is a growing worldwide concern. Laws for the protection of privacy have been adopted worldwide. International legal standards on privacy are European Union, Safe Harbor, Asia-Pacific Economic Cooperation cross-border. Privacy rules, U.S. data privacy laws and guidelines, the Privacy Act of 1974, U.S., Fair Information Practice Principles, Personal Information Protection and Electronic Documents Act, Canada. European Union. European Union, EU, published Articles and Principles for Data Protection in 1995. Objective of the Data Directive, Directive 95/46/CC, was protection of processing of personal data and the limitation of movement. General principle of the directive was personal data should not be processed at all, except when certain conditions are met. These conditions fall into three categories: transparency, legitimate purpose, and proportionality. European Union EU directive is directly attached to privacy and human rights law. Each member of the EU implemented Directive 95/46/CC differently. For these reasons, EU General Data Protection Regulation, GDPR, was created and adopted in April 2016. Data Directive be replaced, and GDPR became enforceable on May 25, 2018. GDPR reformed the Data Directive to strengthen online privacy rights in worldwide. A single set of rules on data protection, valid across the EU. Strengthening individuals' rights so that the collection and use of personal data is limited to the minimum necessary. Rights to data portability to more easily transfer personal data from one service provider to another. The right to be forgotten is explicitly recognized. EU rules continue to apply to organizations outside the EU that handle the data of EU citizens, but it has clarified and strengthened data breach notification requirements. EU enforcement is increased, with between 2% and 4% of a business organization's annual revenue at risk of fines and penalties for data protection. More effective enforcement of the rules in that police involvement and criminal prosecution are tied to violations of privacy rules. Under the Data Directive, global companies could achieve safe harbor status. EU could determine that a foreign organization had sufficient data protection policy and procedures. The organization voluntarily demonstrated an ability to be compliant with the directive. U.S. Department of Commerce oversaw the list and required registrants to renew annually. Under GDPR, companies have to attest and demonstrate that they meet the high standards of the new guidance. If the EU evaluates that a company's standards and procedures are sufficient, the company could be placed on a list known as the Privacy Shield list. Safe Harbor Privacy Principles. International Safe Harbor Privacy Principles were developed between 1998 and 2000 to provide a level of assurance that the privacy controls of U.S. organizations were adequate to protect EU citizen data, per EU Data Directive standards. Safe harbor provisions allowed self-certification by U.S. companies. U.S. Department of Commerce developed privacy frameworks to guide compliance and oversaw the program for U.S. interests. U.S. control frameworks were deemed adequate in 2000. 2015 European Commission ruled that a new framework for transatlantic data flows was needed. This action was in response to the U.S. repeatedly failing to follow the directive. EU determined that a stricter model was necessary. The prevailing safe harbor agreement was ruled invalid. 2016, European Commission and the United States launched a new framework for transatlantic data flows. This new arrangement is called the EU-US Privacy Shield and replaces the International Safe Harbor Agreement. To enable the transfer of personal data from EU citizens to US commercial organizations. The agreement makes data transfer easier while giving data subjects the privacy protection they expect from their own nations. EU-US Privacy Shield designation is specific to the United States. There are a few countries that EU considers to have adequate data protection levels, and data transfers are permitted. Countries that are cleared include Argentina, Canada, Israel, New Zealand, Switzerland, and Uruguay. Countries that are not approved for data protection is achieved by the use of standard contract agreements with EU data controllers to meet EU requirements. Asia-Pacific Economic Cooperation Cross-Border Privacy Rules. Asia-Pacific Economic Cooperation Cross-Border Privacy Rules was developed by APEC. 5 participating APEC CBPR countries are United States, Mexico, Japan, Canada, and the Republic of Korea. Businesses adopt data privacy policies outlined in the APEC CBPR system. An independent APEC CBPR accountability assesses participating businesses for ongoing compliance. Agents' assessments are enforceable by law. U.S. data privacy laws and guidelines. A typical category of sensitive data is PII. PII is any information that can be used identifying, locating, or contacting any specific individual. U.S. privacy regulations are Fair Credit Reporting Act, FCRA, Gramm-Leach-Bliley Act, GLBA, Privacy Act, Children's Online Privacy Protection Act, CIPPA, and Family Educational Rights and Privacy Act, FERPA. Examples of PII are name, personal identification number, address information, asset information, telephone numbers. Privacy Act of 1974, U.S. Privacy Act of 1974, U.S. play a foundational role in protecting individual privacy with respect to information collected, used, and stored by the U.S. government. Privacy Act led to privacy laws and regulations both in the government and in private sector organizations. HIPAA protects privacy and security of information in healthcare. FCRA Federal Trade Commission to promote the accuracy, integrity, fairness, and privacy of consumer information. Privacy Act protects creation, use, and maintenance of personal identifiers. Organizations must provide disclosures to individuals how information has been shared. Privacy Act does not allow disclosure of sensitive information unless it is under limited permissible uses. Fair Information Practice Principles. Fair Information Practice Principles, FIPS, are guidelines by the U.S. FTC. The Code of Fair Information Practices is based on 5 principles. Notice/awareness. The most fundamental principle is notice. Consumers should be given notice before any personal information is collected from them. Choice/consent. The second widely accepted core principle of fair information practice is consumer choice or consent. Choice means giving consumers options as to how any personal information collected from them may be used. Access/participation. Access is the third core principle. It refers to an individual's ability both to access data about him or herself. Integrity/security. The fourth widely accepted principle is that data be accurate and secure. Enforcement. It is generally agreed that core principles of privacy protection can only be effective if there is a mechanism in place to enforce them. Personal Information Protection and Electronic Documents Act, Canada. Personal Information Protection and Electronic Documents Act, Canada, applies to all private sector organizations in Canada. Personal Information Protection and Electronic Documents Act does not apply to government agencies or organizations that do not engage in commercial activities. Personal Information Protection and Electronic Documents Act sets ground rules for how businesses handle personal information in commercial activity. Personal Information Protection and Electronic Documents Act contains 10 principles are accountability, identifying purposes, consent, limiting collection, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access and challenging compliance. Accountability. An organization is responsible for personal information under its control. Identifying purposes. The purposes for which the personal information is being collected must be identified by the organization before or at the time of collection. Consent. Knowledge and consent of the individual are required for the collection, use, or disclosure of personal information, except where inappropriate. Limiting collection. Collection of personal information must be limited to that which is needed for the purposes identified by the organization. Limiting use, disclosure, and retention. Unless the individual consents otherwise required by law, personal information can only be used or disclosed for the purposes for which it was collected. Safeguards. Personal information must be protected by appropriate security relative to the sensitivity of the information. Openness. An organization must make detailed information about its policies and practices relating to the management of personal information publicly available. Individual access. Upon request, an individual must be informed of the existence, use, and disclosure of their personal information and be given access to that information. Challenging compliance. An individual shall be able to challenge an organization's compliance with the previous principles. An exception to HIPAA is information collected, used, or stored for the purpose of journalism, art, or literary material.